Many contracts have what we call a liquidated damages clause that controls what happens in a breach of contract. Of course, there's different types of breaches. If the buyer refuses to close or is just unable to close, the seller's remedy may be to take the escrow deposits that the buyer made. Again, the seller may have a right under the contract to sue to try and force the buyer to close, but it's unlikely to do that other than in the commercial arena. We do see that. If it is the seller that refuses to close, the buyer can either seek a forced conveyance of the property, such as specific performance, or the buyer can sue for loss of the benefit of the bargain, which would be the difference between the contract price and what it costs the buyer to find a similar property in the same neighborhood or geographic region. Most standard contracts in use throughout the state also provide for the prevailing party to get an award of attorney's fees. What's two things that are interesting to note. Florida Supreme Court has said that return of a buyer's deposits where the seller has breached is not sufficient damages to the buyer. The buyer is entitled to more.